All information included herein is provided for general informational purposes by ATN Law Office. What is probate? Probate is the process where a will is registered in a state court and proved to be valid. Once a will is legally recognized by the court, then the estate can be distributed to your beneficiaries. The California probate process can be broken down into 6 basic steps. 1. Validating the will. 2. Appointing an executor. 3. Notifying heirs and creditors of your passing. 4. Inventory of the estate. 5. Paying estate debts and taxes. 6. Distributing the remaining assets. Let's get into further details about each step. 1. Your will must be proven to be valid by a state probate court. Rules and processes of proving your will may vary depending on the state where your will is probated. A will is probated in the state where you lived before you passed away. But if you owned real estate somewhere else, then another probate must be opened only for that property in the state where the property is located. 2. The probate court has to formally appoint an executor. It can be the personal representative named in your will. If you haven't designated one, then the court will appoint an executor. The executor is the one with the legal rights to handle the affairs of your estate. 3. Your executor will notify your heirs, creditors, and the public of your passing. An executor must notify creditors of your passing, publishing the notice of the probate hearing in the paper or contacting the creditors directly. A notice must be mailed to your named beneficiaries, executors, and any heirs who may have inherited if no will existed. Creditors have 4 months to file a claim after an executor has been appointed by the court, or 60 days after direct notice to the creditor. 4. Your executor will inventory the assets in your estate. The inventory is a list of all your assets as they existed at the time of your passing, but only inventory those assets that were not structured to avoid probate. The executor must have those assets appraised for their fair market value at the time of your death, determine how it's titled, file court-approved inventory form, and give notice to your heirs. If new assets are discovered, the executor must update the inventory with the court and give notice to your heirs. 5. The executor pays estate debts and taxes. When a creditor files a claim, the executor pays that debt. The executor also files your final tax return and pays any taxes for an estate that exceeds the exemption amount. In 2016, the exemption amount for your gross taxable estate is $5.45 million. That's $10.9 million for married couples. That is exempt from federal estate taxes. Your estate's taxable year begins the day after you pass away. You don't have to worry about a California inheritance tax because it was abolished in 1982. If applicable, then your executor would only file a federal income tax for your estate. But since the exemption is so high and all property passing to a spouse is exempt, about 99% of estates do not owe any federal estate tax. 6. The executor distributes your remaining assets to your beneficiaries. Before distribution of the estate assets that remain after your debts and taxes are paid, the executor must file a final count and a petition for distribution with the court. At the closing of the estate, the court also approves the fees to be paid to the executor and the attorney. Probate can be a complicated process. If you have more questions, consult an attorney. Remember, planning is the first step in preparing for your future.